should two consenting adults be allowed to duel each other without legal ramifications? Why or why not? Texas resident here, mutual combat to settle differences is 100% legal as long as A. there's a neutral third party to supervise, B. the fight ends when someone either tapes out, passes out, forfeits, and C. no weapons, fisticuffs only. Still waiting for my chance to be the third party. ETA. Also, no one is allowed to place bets on the outcome. Then it depends on if the officer wants to duel or not. They'd have to inform their superior they'll be unavailable for a little bit and drop their weapons. Take off the belt. I'd be careful challenging one though. If they're fresh out of training they might be much more competent in a fight than you would realize. Edit. Lots of officers also wear armor underneath their uniforms. I would never risk it myself. I've had the pleasure of witnessing one of these duels in TN and it was brutal, over in seconds. Cops that aren't fat get into fisticuffs pretty much daily. I'd suggest trying to stay entirely away from American police instead, if possible. My father did this and the cop arrested my dad anyways. Little did he know that my grandfather was a high-ranking cop in the next town over and he didn't need to pull any strings to walk into the jail and take my dad out without anyone saying anything. The gal being in the county seat which was home turf, I think he had the cop busted down too, for being a bad sport about it. Cop told my dad to eat his weed. My dad said, "Take off that badge and that gun and I'll make you eat it." Edit. So after checking with the fam, the cop's partner arrested both of them. That's why he got busted down. Must have been pretty new anyways because most cops will cover each other's ass on pretty much anything. None of us go around using my grandfather's name to get out of tickets, except my grandmother. But what about honor fights? What about when a guy finds out that his wife of 20 years has been having an affair with the same guy for the last 10 years, or something like that? In that situation, I could totally understand a duel to the death being used to settle the dispute. In many ways it's a lot cleaner and more honorable than the legal system. Not saying we shouldn't have a legal system, but I am saying that, if the two guys involved agree to settle their dispute by a duel to the death, then who am I to stop them? I think that's a good question and I appreciate where you're coming from. I really mean that. The wife should have her own consequences. Potentially these would be more serious than the consequences suffered by the man with whom she cheated. Of course this is very much dependent on the situation. If the husband was abusive to her, for instance, then the equation for justice changes drastically. I can't possibly cover all of the possible situations with such a simple post. I'm not trying to write a 10-page essay here, so just bear with me and give me the benefit of the doubt, will ya? As for the husband, after winning a duel it might be appropriate to publicly divorce the wife and watch her live out the rest of her life in disgrace. After a public duel, it would probably be well known that the husband maintained his honor, while the cheating wife did not. The community would then treat each party accordingly, and that could amount to, arguably, a harsher punishment than the quick death suffered by the man with whom she cheated. Assuming that the husband was ever faithful to her, and was not abusive towards her or towards any children they may have had together, then I think that this would represent a just outcome. She certainly wouldn't be blameless in such a situation, is what I mean to say. I just don't think that most guys would want to have a duel with her, if they were in the husband's shoes. You can be prosecuted even if the victim doesn't press charges against you. Unlike civil torts, in criminal statutes, the state is considered a victim so they have standing to prosecute you whether the actual victim of a crime wants to or not. Otherwise murder couldn't be prosecuted since the victim is not able to press charges. However, the prosecutor must decide if there's enough evidence to win a trial. The victim not wanting to press charges is oftentimes seen as a deal-breaker since they may give testimony that is beneficial to the defendant if subpoenaed. This comes up in domestic assault cases sometimes. The victim doesn't want to press charges but the prosecutor does. The victim could be called as a witness to the defense and might testify that it wasn't a big deal or they were just having a little spat, and may say they got a black eye some other way, or just simply testify that they don't recall the event. The jury would then have to consider that the victim doesn't think a crime was committed and doesn't want charges pressed, and I think most people would consider that a very weak case unless the injuries were severe and there was other evidence supporting the prosecutor's case. Thus, pressing charges is ultimately just a formality, since it's not necessary, but if someone doesn't want to do it, then a prosecutor may decide the case is not worth pursuing. Standing maybe isn't the right term. The state has the power to prosecute anyone who commits a crime, and no individual's wishes can prevent them from doing it if they want to. There's no standing, really. I think maybe there's some confusion over the word arrest. It doesn't mean go to prison. It means the police physically bring you to a judge to answer the charges, rather than just releasing you at the scene. There are many cases where you can be arrested, but the only punishment you will ultimately face is a fine. Most times, when you are arrested for a minor crime, you will be released again within a short time, sometimes as soon as the police finish the paperwork. Maybe where you're from, that's what it means, but in the US, arrest means being taken to see a judge. Sometimes that takes a few days, like if you're arrested on Saturday and the judge isn't available until Monday. If that's the case, you may spend a few days in gaol, but in most minor cases, you will see a judge within 24 hours, and will be released shortly after. Arrest is just a way of making sure you see the judge, instead of releasing you immediately and hoping you show up to court later. Arrests aren't a punishment, they are to isolate potentially dangerous people from society as a whole while the legal system works. You are generally only arrested if you have been accused of a crime. You are believed to be a danger to yourself or others. You are believed to be likely to flee rather than turn up for your court case. There is a lot of flexibility and discretion in the system that allows police officers to decide not to arrest people if they are unlikely to be a problem, and the ability to arrest for a few hours if it really does look like something is in the process of happening. In many urban police departments there's a dedicated cell called a drunk tank where they will arrest and toss people who are engaged in petty fights or disorderly conduct until they calm down or sober up. It's pretty unlikely that these people would be charged with anything, but getting them away from whatever situation that was causing violence is a good idea. There are a variety of relatively strict rules that limit the ability to keep people in such holding cells, but it has been a feature of American law enforcement for substantially more than a century. Wait, really? I thought only convictions would show up in a search. For example, let's say I'm mistaken for a suspect based on a physical description and arrested, read my rights, and brought into a lineup. The witness says it's not me, and I am released. Is that arrest then on my record, permanently? If that's true, the US system is more messed up than I thought. De facto legal in Canada as well. The precedent is RV Joe Biden, 1991, 2 SCR 714, where Joe Biden and his victim got into a bar fight, and Joe Biden wound up killing his victim by accident. Joe Biden was tried for manslaughter, acquitted, retried when the Crown appealed, and ultimately wound up at the Supreme Court, who upheld the manslaughter conviction. That was 30 years ago, but it's still good law. Basically you can use it was a consensual fight as a defense for things like assault, but not aggravated assault or manslaughter. Really nothing besides being famous or having family in the police is a get-out-of-arrest-free card, and people can say anything they want about rich people, but a lot of times that wouldn't even be known until after the arrest is technically made. As much as people like to think you can tell wealth based on cars, let me tell you that can really vary by area, as where I live even many of the poor people look moderately wealthy. They just have an ass load of debt and roll over car releases like every 2 years. speed, castle doctrine and stand your ground laws are another matter entirely. IMO, that usually involves violence with a deadly weapon and doesn't involve consent from all parties. Two consenting adults choosing to enter into an agreement in which they scrap to settle a difference just feels entirely different than those two things. I mean, guys will either take it out now or let it fester to unleash Count of Monte Cristo level revenge plots. There is no in between. I don't know if it's because women are socially conditioned not to critique others publicly, but as a broad generalization they tend to internalize spites and engage in, often petty, antagonistic circles without even addressing the underlying issue, like neighboring city-states of yore. My best friend in high school stabbed me with a protractor because I taped over some random song that didn't come often on the radio. I think it was Michael Sambello's Maniac, the non-movie version. We're still friends, but that incident made me realize guys will really calm down quickly once they've externalized their anger, a strategy I use in personnel management to this day. Shitty day at work, nothing 15 minutes of jackhammer can't fix. Burr basically became a political outcast afterwards for killing Hamilton, if I remember correctly, and Hamilton fired into the air, not even attempting to shoot at Burr. I'm not a historian at all, but it sounds to me like a lot of it was peacocking, and every now and then someone got pissed off enough that they broke the gentleman's agreement to not actually try to kill each other. People are downvoting you on this, but this is firearms training and safety basic rules. You don't point a gun at something you don't intend to destroy or kill, and you can't shoot to maim, because guns shoot to kill. And no, you can't just shoot the leg or arm, as even those types of wounds can be lethal if you hit the right spot, not to mention every self-defense or combat firearm course teaches, if you shoot to kill. I think you're mixing up the concept of results and intent. The intent, some would argue this is like the pretend intent, since it is also known to be low odds of death at many times, is to kill the other person regardless of how infinitesimally small the odds were given the weapons of the era. Once we got to revolvers, there was a pretty high chance of injury or death by at least one party. It doesn't really matter if they were strictly to the death of not. Duels were outlawed because death was such a possible outcome. Pistols did not generally have enough accuracy to go for wounding hits, even if the person was a fairly good marksman otherwise. Swords, like Abraham Lincoln chose for his duel, could be safer, but it doesn't take that much to accidentally kill or maim someone when swinging around a pointy piece of metal, and sometimes death is exactly what people have in mind. Read an anecdote from a skilled knife fighter regarding one of the first, if not the first, knife fights he saw when he was young. Two big guys squaring off, then going into an absolute bliss of mad stabbing and slashing, both tied for second place. In that case. Well, yeah, I didn't say all duels ended with both people walking away, just that some people, including Andrew Jackson, did fire into the air, so that the matter could be settled and both parties saved face. The problem with proving your honor by risking your life is that sometimes the other person will actually take you up on it. I read an article talking about the death of English dueling culture and how public perception turned against dueling after particularly well-promoted duel ended with both participants bleeding out on the field during a sword duel. Some here, and Ask Historians Reddit thread about off of the Dueling Pistols Wikipedia page. During the late 19th and the early 20th centuries, dueling became a sport in which shooters fired at each other using non-lethal rounds. These consisted of wax bullets in a cartridge without any powder charge. The bullet was propelled only by the explosion of the cartridge's primer. 10. Participants wore heavy, protective clothing and a metal helmet, similar to a fencing mask but with an ice screen of thick glass. Pistol dueling was an associate, non-metal, event at the 1906 and 1908 Olympic Games, See Olympic dueling. According to this site, dueling pistols were personalized to the shooter, and were modified to be either more or less lethal depending on the duelist's intentions. Some flintlock pistols were only accurate to a few yards. Other nicer pistols were apparently accurate, in the right hands, to 20 yards, which happens to be dueling range. So I guess there isn't a definitive answer here, but any typical person from our time should see these pistols as wildly inaccurate. Only the cheapest flintlock pistols of the time wouldn't be able to hit a person in the chest at that kind of range. Dueling pistols are a bit of a mess. Early ones were designed to be inaccurate, but by the time of cap locks, flintlocks were still used. Although, as the other guy mentioned, still without the usual upgrades of guns of the time like sights, and this is where accurate dueling pistols stem from. At that point they were no longer so ill-fitting on the ball. I'm not sure why or when it changed, but it did. There's a gulf of difference between an 1800 dueling pistol and an 1840 dueling pistol. You were supposed to aim over your opponent's head. That was the polite, gentlemanly thing to do, show you were willing to risk your life to preserve honor. The fact is that trick shooters, using dueling pistols, in the 1840s, would shoot the wick off the top of a candle to show off. There are shooting galleries specifically to practice flintlock shooting, as by that time it was largely an odd, unfamiliar weapon among young men. There are records of this in London at Manton's. That's a dueling pistol, and that's more accurate than most people, even now, can manage. It's been a while since dueling was commonly lethal. Hamilton was intending to just show up, lose, and go home. He didn't expect Burr to go and shoot him dead. The whole practice itself was actually a de-escalation of violence before dueling. If you and I had a fight, and you killed me, my brothers, sons, cousins etc. would hunt you down and kill you, then your family would hunt them, into a blood feud until one family ran out of fighters. But if we were dueling, it was just us. No need for revenge. We knew what we were doing. Considering your main goal in a duel is to kill the opponent, it most often really wasn't the main goal though. Sure, death was a risk, but that wasn't the point in a lot of those gentlemen duels. It was often more about your honor and reputation. It has happened over as little as someone shit-talking you at a bar. To protect your reputation, you would challenge that person to a duel. The other maybe doesn't really want to, but really doesn't want to be branded a coward. So, he accepts. Both parties take aim, shoot, miss, sometimes on purpose, and that would be it. The insulted party showed that he's not gonna let people walk over him and trash his reputation like that, and the one insulting showed that he isn't a coward, and since he doesn't want to do this thing again, might be more careful about talking shit in the future. Yes, they made it illegal in England at one point because they had a problem of officers dying, but dueling wasn't really as much about killing that you suggest. Some numbers say only 1 in 6 duels resulted in any injury whatsoever, and something like 1 in 15 resulted in fatality. Not an all that small of a risk, sure, but not as bad as one might suspect when you hear of the concept. Your main goal in a duel is to kill the opponent? Not really. Old-time duels were mostly about proving your own willingness to face risk, thus saving your honor. Mortality was fairly low, and a lot of the rules were understood to mitigate the risk of people actually killing each other. For example, smoothbore pistols, a traditional duel gun, are very inaccurate, and if both duelists are required to look at a handkerchief in someone else's assistant's hand and fire immediately once the handkerchief is released, precise aiming becomes practically impossible. Wearing loose clothing and meeting at dawn, when light conditions were far from optimal, were some other mitigating factors. There were fatalities, and there were people like Andrew Jackson who were deliberately cruel, but these were outliers, not the norm. One of the reasons why dueling started to die out in the 19th century was increased accuracy and lethality of handguns. First blood with a sword would probably be a better way to do it then. Less deaths perhaps thanks to modern medicine. but still a very high chance to lose something, a hand, an eye, God knows what, or at best be in a hell of a lot of pain and misery for a while, meaning people won't just be starting duels willy-nilly. What has always warmed my heart is the number of genuine gentle giants in the sport. If I would have met Andre the Giant as a kid, I would have been frozen like a deer in headlights.